Short video, we're just going to have a quick look at section 17, liability by holding out. If we go through to section 17 of the Partnership Act, and we'll just highlight this here and copy that into a document up here, which I've done. You'll notice it's got several requirements. So if we go through those in turn, section 17 states that a person, I'll just remove that for the second, a person who by words spoken or written or by conduct. So the person themselves must make some statement or have some conduct where they represent himself or herself or knowingly suffer him or herself to be represented as a partner in a particular firm, is liable as a partner to anyone who has, on the faith of the representation, given credit to the firm. Now, if we follow that through, you can see that it requires an action by the person themselves. You can't be liable under section 17 if someone else calls you a partner and you're unaware of it, or your name is used on a letterhead or on a website. It must be an action you do yourself or an action you're aware of and do nothing to deny. So the action or conduct, and it causes a creditor to believe the person is a partner. So if they know you're not, of course it cannot make you liable. Then the creditor then provides credit because of this statement, so they rely on it and they provide some form of credit to the firm. Then the person can sue that, the creditor can sue the person as though they were a partner, even though in reality they're not. So in other words, if you make statements or conduct and you mislead people, they believe you're a partner, they rely on that, and they provide some form of credit or goods to the firm, you can be sued. Now, I'll be very clear, this is not making you a partner, because partners are liable for all credits, to all creditors. This person is only liable to those creditors that they have cause to believe they're a partner. So it's a limited form of liability. They, of course, don't get access to the assets or have any rights either, so they can't have those debts made up out of partnership assets. There is an exception here, and that's only for a partner who dies, so that if the firm continues to use their name, the partnership business is continued in the old firm name, which is very common. The continued use of the deceased partner's name shall not of itself make his or her executors liable for any partnership debts. So the simple fact of a partner dying and their name continuing in the partnership doesn't make their estate liable to pay partnership debts. You'll notice it says executors or administrators. An executor is the person who manages the will of a deceased person. An administrator is the person who manages the estate of a deceased person who doesn't have a will. Yeah, that's the only difference there. Now, if we have a look at a few examples, the first one is from the semester 2 test example, which is on Canvas, and I've just cut a piece out of it. So changed the start just a wee bit. So the intended partners need some money for bigger workshop equipment. They also need help and invite Mitch to join them. Mitch isn't sure but wants to know more, so he goes along with them to the bank. So clearly at this point, Mitch is not a partner, but he's gone along with the partners to the bank meeting, where he's introduced by Gary as a partner. The bank manager asks if all four are involved in the business. Gary says yes, we're partners, and Mitch says nothing. So that is a very clear example of a person who knowingly suffers himself or herself to be represented as a partner. Right, so the knowingly suffers is to listen to it and say nothing. It's an example of what in law is called acquiescence. Right, a person acquiesces or allows things to appear to be true by not doing anything. So if you, by that I mean by not denying it. As a general principle, if you're part of a partnership or you're a director of a company and you say no, then that's fine. You have denied the statement or said no to the decision. If you say nothing, that will often be interpreted as the same as if you said yes. So you cannot sit on the fence by saying nothing. You can abstain, but you cannot just say nothing. In our second example, Albert retires from the partnership. He follows the rules in section 39, sending notices to all existing creditors and putting a notice in the Gazette to cover all new clients of the firm. But the firm continues to use the old letterhead, and the letterhead has his name on it. Albert sees and does nothing. So we need to add in there the facts that his name is on the letterhead. Albert sees this and does nothing. So he allows it to be continue to be used. So he's allowing the representation that he's a partner. And that creates a liability as a partner by holding out. It would be the same if his name was on a website and he was aware of it and allowed it to stay there. Or you might have somebody put your name on a website as a partner, even though you're not. In the final example, it's a little bit different. This is a partnership by estoppel. Now, if you start Googling on the internet for estoppels, for holding out in partnership, you'll find a lot of law in different countries that looks almost exactly the same as ours. In particular, I think Section 3228 of the Indian Partnership Act, which is very close to identical. However, there is a significant distinction drawn between partnership by estoppel and liability for holding out. We don't draw that same distinction so clearly because there's some minor differences. However, this would be a partnership by holding out, but it also by estoppel, but it also falls very clearly under Section 17. So Frida's negotiating the partnership. She's going very well at the negotiations, and it's all looking good. She goes to a shop where she buys computers. She tells them she's joined the partnership and needs the laptop for the business. So she's representing herself to be a partner. And this is a shop that does business with the partnership, and they ask her if she's a partner. She says yes, which simply confirms her prior statement. Believing this, they ask her to confirm an order for computers for the partnership. She believes that the partnership is going ahead with this order because she heard the partners talking about it, one of her meetings presumably, and she says yes. In reality, they've changed their mind and were intending to cancel. Could Freddie be liable as a partner? Now, the answer to that is yes, because she has herself, by words, represented herself to be a partner. The creditor has clearly relied on it and advanced credit. Therefore, they can sue her. It's possible on these facts that they couldn't sue the other partners because she cannot make them liable, but they will be able to sue Frida. Okay, and that's where we'll leave that particular topic for now.